Good morning. It's 9:05 on 4CRB, and this is The Law and You with Margaret Miller. We have Suzanne straight out of the blocks. Good morning, Suzanne. What can I do to help you?
Yes, good morning. I have two questions about a property for sale. If a person's in an agreement with a real estate agent and the period of time has expired that they gave him, and they haven't done anything about, taking it off the market, but they haven't renewed the contract with him, seeing it's expired, do we still have to send him in writing or just tell him over the phone that, we're no longer want him as an agent?
Suzanne, when you enter into an agreement with a real estate agent, they have to give you an agreement in writing, and that will tell you whether the agreement runs out on a particular date. Ordinarily, in my experience, you find that they have an exclusive agency for a period which you've probably given them, and then after that it continues on unless you give them notice in writing.
Oh, good.
So have a look at your agreement. Have a look at your agreement and see what it says. The time to make the agreement is when you get the real estate agent on board. Obviously, if you only want them to go for 3 months, then you can say in that agreement, it finishes at 3 months whether I give you notice or not.
Yes, I have got that in my agreement, but I was just wondering if I should just still do it in writing just to make it right.
Cover all bases, because without seeing the agreement, I can't give you 100% advice on it. But I think it's better to be careful than not. Also, bear in mind too that where a real estate agent has an exclusive agreement for a period of time, if a person that they introduce later buys the property, then they may be able to collect commission from you. So
that was my next question. Yes. I was going to ask you. They tell me all the time that someone that's really interested, but this person has put nothing in writing. They've just spoken to them. But, if I sort of leave with them and the other agent, they contact him, even though I've got nothing in writing, they could still be entitled to half the commission?
Or even all the commission.
Right.
Ordinarily, if you're dealing with a real estate agent, I would be asking them to give you written reports regularly, listing the people who have made inquiries, so you know who they are. So if they come later with another agent, you can say to the agent, this person was introduced by somebody else. There are cases where things are different when the person comes back, and the first agent may not be liable to get commission, but this is something you need to be very careful about.
Oh, you've been a great help. Thank you very much.
Thank you, Suzanne.
Bye-bye.
Bye-bye. We might take a message from our sponsor while we wait for people to call in.
Did you hear about Jane?
No.
She just moved home care providers.
Really? Why?
Well, home care assistants have no out-of-pocket expense and they're government accredited.
Sounds like a smart move.
And she gets to choose her own caregiver with no contract, no out-of-pocket expense, plus 24-hour care support.
Wow. More for less, hey? How can I contact them?
Home Care Assistance Gold Coast are the home care provider you can trust. Call our sponsor on 55281 643 and make the move today.
Create a cancer-free future. Leave a gift in your will. Supporters who would like to include a gift in their will to Cancer Council Queensland are eligible to book an appointment to have a basic will written or updated for free, thanks to our free will service partners, Atwood Marshall Lawyers on the Gold Coast. Appointments are available between 9am and 4:30pm on Wednesday the 5th of June at Robina and Wednesday the 12th of June at Coolangatta. To make an appointment, please call 1300 66 3936. Your beautiful gift to the future will make a difference.
Welcome back to The Law and You with Margaret Miller from Bell Legal Group. Suzanne raised some very interesting questions. It's always very difficult when you're either buying or selling a property to know exactly what your legal obligations are. And it's very easy to get trapped or to make a mistake because you simply don't know. My advice to anyone who's thinking of buying or selling is to make sure you have a good relationship with your lawyer and speak to them before you retain a real estate agent, and check the details of the contract with the agent. And also, if you're buying a property, before you sign the contract, make sure that your lawyer has a look at it to make sure there are no landmines in it. There are so many cases where people have signed on the dotted line to buy a property, and then they find out there's a problem, and because they have signed a contract, they're legally bound to buy it. and they can't get out of it unless there are particular reasons provided in the contract. Most lawyers, if they're going to do your conveyancing, will not charge you for that bit of initial advice. And that's really where most people get into trouble. There is a Latin saying, caveat emptor, let the buyer beware. And there's nothing more definite than that when you're spending a lot of money buying a property, particularly if it's your home for the rest of your life. You need to understand what's involved in purchasing a property, and if you don't, you can get into a lot of trouble. Suzanne has done the right thing by ringing up and asking, and if you don't want to go to a lawyer, you can always go to a community legal centre. I was at a function last Friday where there were people from the Southport Community Centre and the Robina Community Legal Centre. It costs you nothing to go there for legal advice, and the lawyers there are very good. The Southport Community Legal Centre operates every day, and they have a full-time staff of lawyers, some of whom I've worked with in the past. And the Robina Community Legal Centre, because it's not funded by the state government or the Commonwealth Government, it operates on a Thursday night at Robina. Bell Legal Group volunteers at the Robina Community Legal Centre. So it's a good idea. If you have a legal problem and can't afford a lawyer, take advantage of the community legal centres. We might move and have a bit of music while we're waiting for our next call.
What are you doing for lunch today? Why don't you shout yourself a good old-fashioned pub meal at a good old-fashioned price and head over to our sponsor, the Runaway Bay Tavern. They've got plates to share, salads, pizza, steaks, burgers and kids' meals. Plus, to top it off, at the Runaway Bay Tavern, they have specials for seniors starting from a good old-fashioned $10. Runaway Bay Tavern. Good old-fashioned pub meals at good old-fashioned prices. Located at the Runaway Bay Shopping Centre.
Here's an offer to make you smile. Pay nothing out of pocket for a dental checkup, x-rays and clean if you have Health Fund Extras cover. That's right, a no-gap exam, x-rays and clean at participating Maven Dental practices. Now that's an offer to make you smile. Book your appointment today. Visit mavendental.com.au to find your nearest practice for more information and T's and C's. mavendental.com.au. Maven Dental, making smiles.
A sponsor.
It's 12 minutes past 9 on the Law and You, 5520 8888, or you can email us on talkback@4crb.com with your legal questions. Last week, the two Dans from Bell Legal Group talked to you about powers of attorney and various family matters. They also touched on wills, and one question that we get asked all the time is, particularly where there is a second marriage and someone has children from a first marriage, how do I make my will so that my children inherit despite me marrying someone else? The difficulty is that you can make a will and leave things to your spouse on condition that she or he will say to you, yes, when I die, I'll leave everything to your children. But there is no guarantee, unless you're very careful, that they can't change their will once you've died. And it may well be that your children might miss out entirely. You can talk to your lawyer about making what's called a mutual will, and that in effect is a contract between the two people, so that when you make your will, you make a contract that you will not change the terms of your will and disinherit your children. There was a case recently in Queensland where the husband and wife signed mirror wills, but it didn't specifically state in the will that they promised not to change their will. And of course, when the wife died, the husband met a new partner and changed his will a number of times, leaving the estate to the second wife and nothing to the children. The children applied to the court on the basis that he should have stuck with the first will, and unfortunately, because the will was not properly drafted to protect what the husband wanted, what the wife wanted to do, the children were unsuccessful. They got nothing from the estate, and they ended up with a huge legal bill. We have a call here from Jack. Good morning, Jack. What can I do to help you?
Good morning, Margaret. It's Jack here. I have a very small problem, but irritating. I'm the member of a large motoring group that comes to people's homes and sometimes gets their car working, or in this case replaces batteries. Now, on two previous occasions, I've had to have a battery replaced on the car because it failed while still under warranty. When the battery was replaced with a new one, they shortened the period of guarantee from the conventional or accepted 3 years down to the remaining time left on the guarantee, which in the first case was 12 months, and in the second case with the second battery was the same, another 12 months. And when I queried that, the guy attending the vehicle said it was policy. And I rang the head office and they said it's policy. Put up with it or go somewhere else. But in this particular case, I am a 50-year member of that association, and I think their policy is probably illegal.
I think that policy does stink. Jack, what you need to do when you talk to this motoring body group, you need to say to them, well, under the Australian consumer law, and this is one of my favourite things, something that you buy has to last how long you expect it to last. They can't shorten a warranty period as a matter of policy. If you had a warranty for 3 years, that's what the warranty should be. And in fact, a battery should last more than 12 months anyway. So I'd be saying to them, if the battery doesn't last more than 12 months, I want my money back or I want a new battery.
Yes, well, that's what I've done the second time, Margaret.
Yeah, look, the ACCC recently took Apple to court about this because Apple was giving everyone a 12-month warranty on their products. And, of course, when you're paying $1,500, $2,000 for an iPad, it seems a bit ridiculous. What they did do, of course, is they said to people, well, you can pay an extra $100 and have another 12 months guarantee. But the ACCC took them to court and found that it was illegal, that they only had a 12-month warranty. The product should last as long as you would expect a product to last. And that's something that a lot of manufacturers and people who sell things don't seem to understand.
I appreciate that, Margaret. I imported a motor vehicle from Germany on one occasion, and it came with the battery already in it. One of the top-notch brands, and the battery lasted 11 years. So this has got wings on it when a battery only lasts 12 months or maybe 2 years, and can be quite dangerous if it fails in remote locations. And in this particular case, I have a property in the country that I drive to, and I'm not very well. I have a terminal cancer problem.
Oh, I'm sorry to hear that.
The last thing I want to be is stranded in the bush, with a defective battery. But anyway, thank you, Margaret. I'm very, very appreciative of your reply.
Well, Jack, what you need to understand too is that the newer batteries are in cars that have a lot more things hanging off them. There's, Bluetooth phones, there's radio, there's radios, there's all this electrical equipment that hasn't been in cars previously, which sucks on batteries quite strongly. My best advice for making a battery last longer is to make sure that you have regular long runs in your car, because that keeps your battery properly charged. If you're only doing little trips all the time, your battery doesn't charge up properly in between. And that's something to think about as well.
I accept that.
Thank you,
Margaret.
Jack. Lovely to talk to you. Good morning, James. What can I do to help you? Hello, James. Are you there?
Hi, yes. Good morning, Margaret. How are you?
I'm very well. What can I do to help you?
Oh, I'm just inquiring. I split up with my partner about a bit over a year ago now, and the circumstances was I was helping fix the family home and all that type of thing, renovating, did a bathroom, and there was quite a lot of financial input into the home. The partner owned her own home, but I was contributing every week, on a basis, as you can imagine, like paying for bills and everything like that.
And were you married? Were you married or not?
Yes, we were married in international law, not in Australia. We're married on the ocean.
Well, if you're married under international law, you're legally married. If it's a legal marriage somewhere, you're legally married. Yeah. Are you divorced yet?
Well, it wasn't recognised in Australia, so maritime comes under maritime law. But anyway,
well, that should still be recognised. But the reason I'm asking, James, is because you're in a position, I think you're going to say to me, she's told me I'm not getting anything. Is that the case?
Correct. So,
now,
well, we signed... go.
Now, if you are married, then obviously you can make a property settlement application in the Federal Circuit Court any time up until 12 months after you're divorced without the leave of the court. Now, if you are not married, if you're in a de facto relationship, you've only got 2 years from the date of separation to file proceedings. Otherwise, it's see you later.
But we're still in that period, which is understandable.
That's why I'm flagging it to you now. So keep on going. Tell me your story.
The question I had to ask, there were documents signed in the agreement that an MOU, and I'm not sure whether you've ever heard of one of those.
A Memorandum of Understanding, yes.
Correct. Yeah. So I was never provided a copy of that. I signed it, but it was never provided to me afterwards because it wasn't co-signed.
So she hadn't signed it. Well, what did the memorandum say?
Well, basically an understanding that the property was, in belongings and things like that were settled, tried to make out that, I had no input on the house, no financial gain. It was quite a difficult circumstance, that's all.
Well, you've raised a very interesting question there, James, because this has come up a number of times. When people sign agreements like this, which are informal agreements signed between two people, and they don't have legal advice on them, they're not binding. You can go to the court and just say, well, gee, I didn't get legal advice. Before you sign a financial agreement, there needs to be proper disclosure so that you know what all the assets are and what they're worth, so that you can work out what you're getting is fair. Look, I think if you're not happy about the situation, I'd recommend that you go and speak to a lawyer about it. You've got plenty of time. So the lawyer may well write to your ex-partner and just say, look, James is not happy about how things have worked out. Let's have a discussion and see if we can do something that's a bit fair. And if you can't reach agreement, then you're in the position where you can file proceedings in the Federal Circuit Court and litigate it. While a lot of people say the Federal Circuit Court takes forever, at the moment, they're taking a couple of years to get to trial, but most matters settle early in the piece because the judges are absolutely wonderful. They're very proactive, and if somebody's dreaming and being unreasonable, you'll get the feel of it very early in the piece, which is why a lot of people settle. That's the way to go, James.
Excellent. Thank you very much, Margaret. I really appreciate it.
You're very welcome. We have, I think, our last call from Murray. Good morning, Murray. What can I do to help you?
Hello, Margaret. How are you?
I'm really well. What can I do to help you?
Margaret, a point you were discussing previously about a second marriage.
Yes.
Or a third marriage and the children's inheritance. You didn't seem to mention the superannuation, which, of course, is a separate item.
Superannuation is not generally a part of an estate.
No.
It's like an insurance policy.
It's overlooked many times.
Yes.
And seeing you were discussing it, I thought it might have been purposeful to mention it.
Yes.
Thank you very much.
That's a good thing to mention. What you need to bear in mind is that when you're making a will, generally a husband and wife will own a house, and they might own the house as joint tenants. Exactly. Instead of tenants in common. And if that's the case, at the instant of death, the ownership of the house passes to the survivor. The house never forms part of the estate. And it's the same with superannuation. Superannuation is like insurance policies unless there is what's called a binding nomination paying the money to the estate. It's paid to the beneficiaries that are nominated by the person who owns the policy.
That's right, but the will has to reflect that.
The will doesn't have to reflect it because the super's not in the will. Super is outside the will. So if you wanted to make sure that your children got your superannuation and not your spouse, I would recommend doing a binding nomination because that binds the trustees of the fund to do what you say. If you don't have a binding nomination, you can put down a beneficiary, but the trustee of the fund determines how the money is divided, and other people can make a claim. Other people who are eligible beneficiaries can claim. The binding nomination will stop them from doing that.
Yeah, but the binding nomination has an expiry. They usually have 3 years. And
there's two sorts. There's a non-lapsing binding nomination and a binding nomination which lapses. You can, in a lot of cases, make a non-lapsing binding nomination. You need to ask your fund. I know my fund has that. So just check and see. If it is a binding nomination, yes, it is 3 to 4 years.
Yeah. Yes. It's superannuation. You've got separate laws, haven't they?
It's outside an estate. It's a separate thing.
Yeah. Okay then. Thank you, Margaret.
Thank you, Murray. Lovely to talk to you. This has been a most interesting dabble in the law. We've had quite a range of questions being asked. This issue of superannuation and wills and leaving things to families, it's quite an important one for a lot of people. So I don't understand why people do their do-it-yourself wills. It's just too important to make sure that people understand what you want when you pass away. And when you're looking at the size of some of the estates now, it seems a bit crazy to use a $20 or $30 will kit when you can see a lawyer for not a lot of money and get everything absolutely right. This is The Law and You with Margaret Miller. Just to remind you, there's 218 days to go until Christmas, and I will be back on the program again next week. We might go to the news now. Thank you for listening.